everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty at iExamBee. I'm back again with the next video of my series Landmark Judgments. And this is a very innovative series. Let me tell you, it is very helpful for all those who are related somehow to the legal discipline. They can be practicing in courts, they can be law students, they can be academicians, they can be preparing for competitive exams like Judiciary and CLAT, where judgments are very important. Current affairs, legal current affairs are important. So do subscribe to our YouTube channel and stay updated with all such kind of beneficial videos. These are very short, crisp videos that are giving you a brief idea of all the recent judgments that have been passed in a month-wise manner. Rather, I have divided it into two videos a month. First 15 days, one video, and second 15 days, one video. Now this is the second video in which I will be discussing the judgments from 16th to 31st of January. So आप लोग please इस video का benefit लीजिए as it you are getting everything in one video in a very short and crisp manner. Don't forget to subscribe, and if you have any queries or doubts, you can write to us at hello@iexambee.com. One more suggestion. If you want, rather you should download all these PPTs with these videos. These will be records with you. You will get ready-made PPTs for all the case laws with you. So that is a very good thing. You can make a compilation for yourself. So please don't forget to download it and keep a record with you. The landmark judgments that have been passed, landmark in the sense which are having some rather every judgment is important, but some judgments are reportable, some judgments are quite unique that have been given by our apex court and some high courts. So those judgments we will be discussing in this video. 16th to 31st of January के judgments हम लोग इस वीडियो में डिस्कस करेंगे. 1st to 15th January के judgments का वीडियो अगर आपने नहीं देखा है, do go to the playlist of LegalBee and check out that video as well, and stay tuned for all further videos. February and so on के videos भी आपको every 15th and last day of the month you will be getting these videos. Starting with the first one, that is of the Supreme Court. Honorable Supreme Court has in Jasbir Singh versus State of Punjab on 19th of January delivered a judgment. It is relating to criminal law. Apex Court has converted the conviction of an accused from 302 to 304 part 1 of IPC. अब हमें ये समझना होगा कि क्या grounds थे जिसमें conviction को reduce कर दिया गया and 304 part 1 में उसको punish किया गया. So the exception that is there under section 302, उसका जो benefit है 300 rather, उसमें एक exception है private defense का. तो वो प्राइवेट डिफेंस का एक्सेप्शन का बेनिफिट अक्यूज्ड को मिलना चाहिए था. दिस वाज व्हाट वाज हेल्ड बाय द कोर्ट, एंड इन दिस पर्टिकुलर जजमेंट दैट द कंप्लेनेंट वाज एन अग्रेसर पार्टी. तो अग्रेसर पार्टी के सेल्फ डिफेंस के लिए जो एक्ट था अक्यूज्ड का, दैट वाज अमाउंटिंग टू एक्ट एज पर सेल्फ डिफेंस. सो इट इज कवर्ड अंडर एन एक्सेप्शन to section 300 of IPC, and it is automatically converted from murder to culpable homicide. So this is a very recent judgment, 19th of January का judgment है ये. You can visit and read the entire judgment for your understanding. Next is again Honorable Apex Court has passed it on 19th of January. इसमें conviction नहीं, but इसमें acquittal है. Acquittal of the accused from again 302 of IPC has been given by giving benefit of doubt. Now what was the reason? The reason was inordinate delay in recording statement of witnesses. Therefore conviction cannot be stand. This was held by the court. Now witness was the only eyewitness that was available, and there was no further corroboration. Okay. What is important is that there was no further corroboration. If there was no corroboration and the statement that has been recorded by the witness, that is also with inordinate delay, the delay is not explained, then automatically doubt arises in favor of the accused, and benefit of doubt must be given to him. Therefore acquittal was granted by the Apex Court and High Court's judgment was overturned. Prasad Pradhan and another versus State of Chhattisgarh 24th of January को ये judgment आया है. This is also relating to criminal law. This is actually a confirmation of conviction which Chhattisgarh High Court had given. Chhattisgarh High Court had given a confirmation that it is a case in which 302 and 304 has again been discussed, that in this situation Supreme Court has said what was the ground that was taken while challenging the conviction, that the nature of injury, after the injury basically there was lapse of a lot of time for death, means injury होने के बाद death immediately नहीं हुई थी. If the injury would have been sufficient in the ordinary course of nature to cause death, then the death would have taken place soon. But this defense is not a valid one, that there is a lot of time gap between the injury and the death caused. That cannot be considered as a situation that it is not 300 and culpable homicide. So Supreme Court has upheld the conviction of Chhattisgarh High Court and said that, emphasizing that such a lapse of time would not constitute a determinative factor to diminish the offender's liability from the offense of murder to that of culpable homicide not amounting to murder. This is, I would say, again a very important judgment that we have got on murder and culpable homicide. So recently हमें, you can see अभी के अभी हमने 3 judgments discuss किए हैं relating to criminal law, and all these 3 are very important for your understanding about culpable homicide and murder. Now let us see a judgment from the civil law as well. It is another very important judgment. 25th January को ये judgment आया है. Ikumalai @ Urf Venkatesan and another versus M Kamala and others. इसमें क्या हुआ है? You can read the judgment summary or you can read the judgment in detail. It will help you clear many concepts. इसमें एक we can say मैं आपको शॉर्ट में बता रही हूँ कि क्या होल्ड किया गया है. यू नीड टू रीड द फैक्ट्स, क्योंकि सिविल केस है ये. फैक्ट्स मैं आपको इस वीडियो में बताऊँगी, तो पूरा वीडियो में यही कवर करना पड़ेगा हमें. सो व्हाट इज़ द थिंग इन दिस केस? Release deed was in question, that whether that release deed is actually amounting to a lawful transfer as per section 6 of Transfer of Property Act, because the concept of pes successionis and doctrine of estoppel was actually, by the way, discussed in this along with that. So what Supreme Court has held, that estoppel cannot be warded off by persons claiming through the person whose conduct has generated it. That means एस्टॉपल का जो कंसेप्ट है उसको इम्पोर्टेंस दिया गया. रिलीज डीड करने से जो एस्टॉपल जनरेट हुआ है, जो जिस इंसान ने किया था एक्चुअली उसकी डेथ हो चुकी है, तो उसके जो लीगल हेयर्स हैं वो उसका किया हुआ एस्टॉपल वॉर्ड ऑफ नहीं कर सकते. दे कैन नॉट चेंज दैट. Even if they are saying that the release deed is not a lawful transfer in those facts and circumstances, but the estoppel that has been generated by their father's conduct, that cannot be warded off. This was held by the apex court in this particular judgment. So you can read the judgment in detail, that why this release deed was challenged as not being lawful, and what was the doctrine of estoppel, what were the aspects exactly discussed by court in this judgment. Naeem Ahmed versus State of Delhi, National Capital Territory, 30th January को ही ये judgment आया, very recent. This is relating to acquittal of an accused again, which is regarding false promise to marry. Supreme Court has made a distinction between false promise to marry and breach of promise. Supreme Court has said that false promise to marry can be said that it amounts to rape of the prosecutrix in this particular case. But in this case, it may happen actually that the while making the promise, the intention was good, but later on, due to some facts and circumstances which have arisen subsequently, they have been encountered unforeseen by the person and beyond his control, then that can prevent him from fulfilling his promise, and that will not amount to false promise, but it will amount to breach of promise. So if there is a breach of promise, then in that particular case, it would be folly to treat each breach of promise to marry as a false promise and prosecute that person for offense of rape. So in this particular case, the court has held that you cannot prosecute that person for rape offense under section 376 of IPC, because that promise is not falsehood, but it is a breach of promise. This was the conclusion of court, and he was acquitted. Usha Chakrabarti and another versus State of West Bengal and another. In this case, the apex court has directed the quashing of an FIR. Quashing of an FIR was directed on account of facts that are of civil nature. The dispute was actually of civil nature. So the FIR that was lodged against that person, that was caused by the Supreme Court. Supreme Court has actually directed quashing of FIR rather, because High Court has not entertained the case and has come to a conclusion basing on the case diary in this particular case कि इसमें case diary में कुछ ऐसी चीज़ें हैं that investigation should be moved forward. This was the conclusion of High Court, but Supreme Court said that in this particular case prima facie we can make it out that there is a civil dispute. तो अगर civil dispute है तो फिर you cannot use the criminal proceedings as a weapon of harassment against the appellant. So that's why section 482 CRPC के हिसाब से this FIR should be quashed. This was held in this particular case. Shailesh Kumar versus State of Karnataka. Now let us see some High Court judgments. Karnataka High Court का judgment है ये कि simply taking the name of caste of a person belonging to scheduled caste or a scheduled tribe without any intention to insult or humiliate that person would not become an offence under SC/ST Prevention of Atrocities Amendment Act 2015. यानी कि ये एक अमेंडमेंट, ये एक एट्रॉसिटी नहीं होगा सिंपली अगर आप कास्ट का नेम लेते हो. तो दिस इज व्हाट इज अनदर इम्पॉर्टेंट जजमेंट. Next one is of Madras High Court, that is Designated Officer the Food Safety and Drugs Control Department versus Jaya Vilas Tobacco Traders. Now in this case Madras High Court has held that currently there is no law which is putting permanent ban on tobacco. So only temporary measures can be taken for controlling tobacco, but you cannot impose a permanent ban on it. That is, the government or the Food Safety Commissioner cannot do that. So that was held as unlawful and illegal. Lastly, Bombay High Court has also passed another important judgment on 20th of January, ABC versus State of Maharashtra and another, in which court has allowed the termination of a 33-week pregnancy. Now this is beyond the gestation period, and this was something which requires MTP Act requires that the woman has to face medical board for that purpose. But court has held that in refusing a medical termination of pregnancy only on the ground of delay, this court would not only be condemning the fetus to a less than optimal life, but would also be condemning the mother to a future that will almost certainly rob her of every positive attribute of parenthood, because the fetus was having some abnormalities. So the court, considering the facts and circumstances that are arising due to that abnormality of fetus, जो actually एक हेल्दी लाइफ फीटस को नहीं दे पाएगा, एंड मदर भी वो चीज़ के लिए रेडी नहीं है, शी इज़ नॉट एबल टू हैंडल दैट पर्टिकुलर सिचुएशन विच विल अराइज. सो कोर्ट हैज़ परमिटेड हर टू terminate the baby even if it is 33-week pregnancy. So this was also another important move by the Bombay High Court that was made in this particular case. Delhi High Court has also made a judgment that is relating to right to information, and it was passed on 25th of January. That right to information, what things are considered under it. Actually in this case what was held, what was requested, an application was filed under RTI that was relating to information for money laundering, business, hawala money transactions, smuggling activities. So जो ये सारे एक्टिविटीज़ से रिलेटेड इन्फॉर्मेशन मांगी गई है, उसको एक एक्सेप्शन क्लॉज में फिट करने की कोशिश की गई थी, करप्शन और ह्यूमन राइट्स वायलेशन. सेक्शन 24 अगर आप पढ़ोगे आपको ये केस और अच्छे से क्लियरली समझ में आ जाएगा. सेक्शन 24(1) of the RTI Act and the schedule, it provides exceptions if the information is relating to certain corruption or human rights violations. But Delhi High Court has held that इस केस में ये एक्सेप्शन अट्रैक्ट नहीं होता है. सो दिस इंफॉर्मेशन विल नॉट बी गिवन टू यू. This information will not be covered under RTI, and that RTI application should be rejected. So this has allowed the writ petition and set aside the directions of Central Information Commission. So ये section 24(1) of RTI Act अगर आप पढ़ लेते हो आपको और अच्छे से ये situation समझ में आ जाएगी कि ये RTI Act का section actually बोलता क्या है. It provides for information from actually certain intelligence agencies. So ये security agencies, intelligence agencies information देने के लिए वैसे bound नहीं होते हैं until and unless there is an exceptional situation like human rights violation and corruption. सो कोर्ट ने बोला है कि इस केस में ऐसा कोई भी एक्सेप्शन अराइज नहीं होता है, सो दे आर नॉट बाउंड टू गिव यू द इंफॉर्मेशन ऑन योर RTI application. So this was all that we had from the month of January, and don't forget to subscribe and stay updated with all such beneficial videos. Thank you everybody.